Okay, the record should reflect Ms. Sunday's present here in the courtroom today. This is the date and time set for sentencing in this matter. Ms. Sunday, have you had an adequate opportunity to go through the pre-sentence report and talk to Ms. Stoke about that?
Yes, sir.
Stoke, are there no additions, deletions, or corrections that you have reported?
No, we read the report together and Ms. Shelby did not indicate that there was anything that was incorrect in the report. I did not find anything that was incorrect.
And are there any challenges to the scoring?
Misdemeanor, Judge.
It's a misdemeanor, so there wasn't scoring.
Okay. Ms. Koch, any additions, deletions, or corrections?
No, Your Honor.
Anything on behalf of the people for allocation today?
Your Honor, I struggle with these cases where we send them to sobriety court because I know sobriety court is difficult and it's a difficult thing. It's the recommendation here, I think, was 5 days with 1 day credit in the probation to finish the sobriety court. So I hope she's very successful in that. You know, she had a prior OWI in 2013, and then she had another OWI in 2019. Then she had a DWLS that got dismissed in 2025. So I don't know what needs to happen in her life for her to take this seriously, and I hope that sobriety court does that. Otherwise, she's probably looking at significant jail time. So thank you, Your Honor.
Mr. McFarland, do you have a copy? Left it in my office. I know I read through it prior to the hearing. Okay, thank you. Ms. Doe, anything on behalf of yours?
Yes, I want the court to know, this case has been proceeding for quite some time. It started in February of 2025. We had the ice storm, and Ms. Shelby hired me during that, and there was some delay in the proceedings then, and then we've had substance abuse evaluations and some things happen, but the amount of time that has elapsed has allowed me to get to know Ms. Sunday pretty well. She's invested herself in being sober. She's not had any slips since this incident happened. She's dedicated to a sober lifestyle year out. And I think that's a big difference. I think before she wouldn't have admitted that she really had a problem with alcohol. Today she knows and understands that she does, that she can't go back to that lifestyle. Something that is going to be difficult for her is that she does not have insurance that covers the counseling for sobriety court. So she has to pay out of pocket $120 a session for a counselor over the next year, anytime that they're requiring her to do that counseling. That amounts to right around $500 a month in expenses for her, in addition to testing expenses and other expenses for the program and fines and costs from this court. She has $200 to put towards fines and costs today. Would ask that the court would allow her to make a payment plan to the court after that because of the significant expenses that she's going to incur in sobriety court. She was talking to me this morning about asking the court to try to fashion some alternative to jail time. Although I told her I believe that the statute says that the court has to impose jail for 5 days. She wanted me to request some sort of house arrest because she really wants to be able to work to try to save money so that she can afford all of the expenses for sobriety court. So that is her request today, that the court would consider perhaps giving her house arrest so that she could continue her employment over the next 4 days. Although she has prepared herself to come today to serve the days that were recommended. And I did tell her the court could exceed those days in its discretion. But I think she's made great efforts during the time that she's been under bond, and we would ask just those possible options from the court and the court's discretion. And I know that she does have something to say as well.
All right, thank you. Ms. Sunday, anything you wanted to say?
Yes, Your Honor, I just want to say that I apologize for putting the court through this and myself as well. And if I were able to be be able to be on house arrest or anything else I'd be able to do in order to not have to serve so I can get back to work tomorrow. And also, I've already talked to the probation officer in Sheboygan County about having to pay out of pocket for my sobriety court. So they're aware of it and also are working with me and being able for me to work the days I need to work and also get through my sobriety court and successful with it.
All right. On the Sunday, I did read through the report prior to the hearing today, so I'm familiar with the circumstances that bring you before the court. I'm also familiar with your background and so forth based on the information in that report. I take all of that into consideration along with what the lawyers and yourself had to say here today. Certainly the circumstances that led to your arrest here are concerning. Had a fairly high blood alcohol content at the time. Certainly pose a danger to yourself, other people who are on the road. So this business that restarted and ended up. So very dangerous situation. You operate a vehicle with that kind of blood alcohol content, back roads as you have. So that's certainly concerning. I do think though that there's certainly the potential for rehabilitation here. Sobriety court, as acknowledged by the lawyers, it's not an easy road. I used to preside over a sobriety court, so I know that it's very challenging. And it takes a lot of commitment on the part of the people who are participating. And what it really takes to be successful is for you to want to do it for yourself, not just because it's a better way out of the charges or because the court's requiring you to do it. It's because you don't want to wind up in this situation again. You want to use all the tools that are available. So I hope that's how you take it, how you go forward with it. I hope that you are successful in that. I think there's every indication that you could be. And so I hope that is the way that it goes. And I'm going to follow that recommendation. In terms of the jail time, the statute is what it is. It says you got to do 5 days. Because you're going to participate in this program, I'm not going to impose any additional jail time over above that. Although I think the circumstances of this offense could call for more jail time. But because I do see the ability for rehabilitation and statute. So I am going to follow the recommendation. The court is going to sentence you to probation for a period of 2 years. The court is going to adopt as the conditions of your probation all the terms and conditions listed in the report. The most important of which, of course, is that you participate in successfully complete the Sheboygan County Sobriety Court program. The court is going to order that you serve 5 days in the Crawford County Jail with credit for 1 day served. That time to be served up front beginning today. Court is going to order restitution in the amount of $100 payable to the Crawford County clerk to be dispersed to state police. Crime victims assessment of $130 or cost of $325. An OUIL reimbursement fee of $150 that will be dispersed to the prosecutor's office. The DNA testing fee of $60 and a $50 state cost. Mr. McFalda, do we impose a supervision fee when?
I didn't recommend one just because her participation in sobriety court, I just felt like they will be doing the majority of supervision. I thought they would be just an added expense.
Okay. So that is listed under paragraph 17, but I'll strike that. The court's not going to impose a supervision fee. And then Sunday, in terms of the court costs, it's $200. That's something that the court, community service or states need to do, as opposed to the other costs are statutorily required to impose. So there's nothing I can do about those. So, but to the extent that we can waive or reduce the court costs based on community service or some other way, talk to your sobriety court agent about that. I'm certainly would consider waiving that in lieu of something else to help with the fight. I know it's a big financial.
Thank you.
You do have the ability to seek an appeal of the sentence. And the scope, there's the appellate rights on the table there. If you can, on this Sunday, review those and just acknowledge receipt.
Sure. I'm handing her the notice of right for public review.
Just make sure they're hers, because I just put them in a pile.
They're stapled together. isn't
Yes,
it?
yep. So I'm just making sure that her name is on there, because everybody's is together.
Oh,
Yes,
oh, I see. I got the word.
And then just for the record, the court has signed the memorandum.
so
of
she's the second, so she
understanding.
couldn't see here, so she's not gonna have to.
Oh, that's right. Okay. Sorry.
Jody, there's no appellate rights because it's a misdemeanor.
It's a misdemeanor, so there aren't.
Sorry.
Appellate rights.
Okay, yeah, there's not one there with her name on it.
I'm thinking we're dealing with the third here.
Right.
So, this Sunday, there's nothing that you're gonna receive in writing, but you do have the ability to seek an appeal of the sentence. If you wanted to do that, you would file for that appeal within the next 21 days. If you have further questions about that, talk to Ms. Doge, explain that process. to you. Spoke anything further that we need to address today?
No,
Just, does she then need to report to both places for probation? She'll need to report to this court and to sobriety court?
I will discuss that with her when I go over her probation order, probably tomorrow.
Okay, so she'll need to report to you initially then.
I'm gonna see her at the jail tomorrow. She'll
Okay.
be there. That'll be easy for me to see her, go over her probation order. And then what I'll do is transfer her up to Sheboygan. The agent up there with the Department of Corrections may just place her on administrative because sobriety court, but I'm gonna let them work that out. Every
Appreciate it.
county does it a little bit different.
All right, thank you. I appreciate that clarity.
Unless I didn't have to go with the officer now, good luck to go forward.
Thank you.
Thank you, Your
You
Honor.
can grab it.
Thank you. Have a great day.
Number 245281.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Jason Thompson, duty attorney. I did receive a copy of the amended probation violation. I just want to make sure we're all working off the amended one. And discuss it with Ms. Leland and Mr. McFalda. Mr. McFalda offered that if Ms. Leland is pled guilty to technical violations, count 1, count 2, count 3. And the one on the bottom that says count 1 should probably say count 7. The one that's occurred on 2-4, the use, that you would dismiss counts 4, 5, and 6. That would be 4 violations, so that would give the court discretion in sentencing up to the maximum on the original charge, which is possession of methamphetamine. My understanding, Ms. Leland wishes to plead guilty to that.
Right, Mr. McDowell, is that a correct statement?
That's correct, Judge.
So 1, 2, 3, and 7.
Yes.
Ms. Leland, have you had an opportunity to speak with Mr. Thompson about this?
Yes,
Okay, is that how you wanted to proceed today? Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Ms. Leland, let's see. Understand that by pleading guilty to the probation violation, that it could subject you to the maximum possible penalty on your underlying charge, which is up to 10 years and or $15,000 fine. Do you understand that? I need you to speak up a little.
Yes.
Thank you. You understand that you have the right to have a hearing as to whether or not you violated your probation, and that by pleading guilty, you're going to be giving up that right?
Yeah.
And is it your wish to proceed with this guilty plea here today? You raise your, did I already swear you in? Okay. Has anybody threatened you with anything to get you to plead guilty? Has anybody promised you anything other than what we said here in court today? Is it your own free choice to enter these pleas? Are you pleading guilty to violating your probation because you did actually violate your probation? All right, so let's start with count 1. Back on December 10th of 2025, you were on probation out of Crawford County, is that correct?
Yeah.
And you were aware that one of the conditions of your probation was that you were to not use or possess any controlled substances unless they were prescribed to you. Do you understand that? On or about that date of December 10th, 2025, did you use methamphetamine?
Yeah.
Was that something that was prescribed to you?
No.
Were you also ordered at that time to participate in substance abuse treatment?
Yeah.
Did you fail to follow through with that?
Yes.
Back on January 19th of 2026, you were still on probation. Is that correct?
Yes.
Were you aware that one of the conditions of your probation was that you were to participate in drug testing as directed by your agent?
Yes.
Did you fail to appear and test for drugs on that date of January 19th?
Yes.
Okay, and then February 4th of 2026, you were still on probation, is that correct?
Yes.
On or about that date, did you use methamphetamine?
Yes.
Did you have any prescription or any legal right to use that at that time?
No.
All right, thank you. The court finds that the plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you did violate your probation as alleged. Court will accept your guilty plea as to each count. In terms of sentencing, Mr. McDowell, were you going to prepare an updated report?
Yes, Judge.
Okay. So we'll set this for sentencing at a later date. Between now and then, Mr. McDowell, you're going to meet with him to do updated pre-sentence report, and the court will set this for sentencing. Mr. Thompson, have you talked to Ms. Leland about appointment of counsel? I know you're appearing today for purposes of arraignment.
We did not discuss counsel for sentencing.
Okay. Ms. Leland, did you wish to have an attorney represent you at the sentencing hearing? Okay, so the court will refer Ms. Leland's case for appointment of counsel.
And Your Honor, I wasn't aware of this file before I came in this morning. Who is the attorney on the underlying case?
Looks like you.
You were.
Okay, I'll be appointed on this, Your Honor.
Oh. All right, so the court will order that Mr. Thompson be appointed to represent the purposes of sentencing. We need to address bond in that sentencing.
Judge, yeah, I would like to address bond. I do think a cash, I think a high cash bond is appropriate in this matter, Judge. You know, she pled to possession of methamphetamine. Remind the court that she was a co-defendant on a case where there was 324 grams of methamphetamine in the car and a loaded handgun. She was a passenger driving north from down south with all these narcotics in the car. She's really had nothing but problems since she's been on probation, not complying with, you know, various orders. I actually could charge her with several other counts of failing to appear for her counseling. I do think a bond is appropriate. There is going to be a jail recommendation. As far as her sentencing, I think she should be held pending sentencing.
All right, Your Honor, I would ask the court to take into consideration Ms. Leland voluntarily appeared today. I mean, she knew she'd been having the troubles with the testing that brought us here today, but she still appeared today in court. I believe she's historically appeared. I don't have the file in front of me. Would ask the court to take that into consideration.
All right, so Ms. Leland, you were just placed on probation in the middle of November. You were given the benefit of a really light sentence given the nature of the crime here. You were sentenced to time served, which is 37 days at that time, placed on probation. It appears that probation has not really gone very well so far. You have not been compliant. The court also notes that over a 1 year period, I believe that you were absconded, there was a bench warrant out for your arrest. I think that was issued in January of 24. You weren't brought before the court and arrested until October of 2025 or September of 2025. So a significant period of time that you were absconded in this case. So for those reasons, I do find that a high bond is necessary to ensure your appearance. I also think it is likely that you're going to face some jail time. And so I agree with Mr. McDowell. The court is going to set bond on $50,000 cash or surety. And then we'll set this for sentencing. What's next available date? And so the court officer right now. And, we'll proceed with sentencing when the court can get that scheduled. Is Mr. Wakely here? Dale? People versus Wakely, file number 255479.
Sierra Coke on behalf of the people.
Good morning, Nicholas Robinson on behalf of Mr. Wakely. Coming up to the podium right now.
All right, we have this set for a jury trial set to begin next Tuesday, February 10th. This is the final status conference and plea cutoff. Mr. Robinson, have you had an opportunity to speak to your client about the plea cutoff?
We have, Your Honor, and Mr. Wakely would like to exercise his right to a trial by jury.
Okay. So we'll proceed with trial as scheduled next Tuesday on this file. I looked, we also have the stack with Doreen.
We do, but this case actually was charged 4 months before Doreen on 5/20/25 and is a capital case. Doreen is an FH and this is an FC. So we'd ask that Mr. Wakely's trial go. We are prepared.
Okay. I mean, it's capital because of the individual, but it's not a capital charge.
Right.
All right, so I do think it would be appropriate to proceed with this file. I think it has priority over Doreen. So we'll move the Doreen, reschedule that one, and we'll proceed with trial scheduled. Ms. Koch, I'm not sure, have you already submitted your jury instructions?
No, they'll be submitted today. It's a pretty straightforward case. The only foreseeable issue I see for the jury trial is that the case has a search warrant. The search warrant was a result of multiple controlled buys into Mr. Wakely. So there may be issues in the trial where there are questions regarding that may be an issue, but that's the only legal issue that I foresee in this trial. It's very straightforward.
I agree with that, Your Honor. We have not filed our instructions either. We'll have that in by tomorrow at the very least.
So I'll just ask that both sides submit any instructions in Word format in case I need to edit them. Mr. Robinson, it's not necessary for you to submit a full set of instructions. If you can just review this, folks, all I really need you to submit are ones that you object to, disagree with, or alternate or additional instructions.
Very good.
And if you can provide those electronically to my office. And Mr. Robinson, just typically, I don't know if you tried a case in my court.
I've done one with you.
Have you? Okay,
Yeah.
so you know, we start right with jury selection, go right into proofs as soon as we get to jury selection. So,
No problem.
okay.
Out of curiosity, what's the weather expected to be like up here next week?
Hey, that's a good question. I haven't looked that far ahead.
Not bad.
Cold. All right. Cold and snowy, I think. If we count on that.
Okay,
Safe.
fair enough.
So yeah, I'll just ask both counsel and Mr. Wakely if you get to be here and ready to go by 8:30 in the morning of trial, and we'll get started. Ms. Koch, anything else we should address?
Nope.
Oh, Your Honor.
Thank you.
Thank you very much.
Okay. Versus Anthony Doring, file number 255475.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, Anthony Doring. Your Honor, we were here, we were the court's ruling about the order of trials. We have no objection to that. We just asked that our trial be reset. I would ask that the final status another final status conference, we cut off the extended. Ms. Koch and I might possibly have just a little bit more talking to do, given some recent events. But I think essentially we were prepared for trial. I believe we'd already submitted our jury instructions to the exhibit list. It's going to be a straightforward trial, and I don't foresee any problems with getting this done in one day.
Okay, let's go.
We are ready to proceed to trial. We can just move it. I can continue to talk to Mr. Thompson. We've talked numerous times regarding this case, and I'm sure we'll continue. If we want to do a final status conference, since we're moving it, that would be appropriate too.
Okay, I will do that. Ms. Coker's still one day.
Yes.
Mr. Doring, did you have any questions about how we're going to proceed?
No, sir.
Thank you. Just make sure that you continue to stay in touch with Mr. Thompson.
Yes, sir. Thank you.
All right, thank you, Your Honor.